Sorry. Hello. Hey, hi everyone. Good evening to all of you and welcome to IMTS. How are all of you doing? I hope everyone can hear me clearly. Okay, great. So, how was your Eid? How was everyone's Eid? I don't know what happened with the PPTs. showing errors. Okay, 1 second. Let me upload the PPTs again as some error it's showing. Uh, does anyone have any questions related to the topic we have covered on Thursday? If anyone has any questions, they are free to ask. All of you are free to ask me. No questions? Okay. So today we are going to study about Companies Act. So I will be discussing the Company Act of India. Okay, and it is more or less same to the as compared to other countries. Okay. Can all of you see the PPT? Can all of you see the PPT? Monachin says yes. What about others? Remaining 8 students. Lazy says yes. Prabha says yes. Lenin says no. Sujit says yes. Nixon says yes. Lenin, what happened? You cannot see the PPT? Lenin, is it loading? No, it's already loaded. It's already uploaded. If you can't see, just log out and try to re-log in again. So there are two PPTs actually. Okay, so in India, the Company Act was constituted in the year 1956, and also in the year 2013, that is last year, some amendments were done in the Parliament related to Companies Act, or we can say it has been upgraded. So we will go through both the Companies Act, that is the Companies Act of 1956 as well as the Company Act of 2013. So this file is loading. I don't know why it's not getting loaded. 2013. Anyways, let's start with the Company Act of 1956. Can all of you tell me what does the term company means? What does the term company means? A commercial business. Okay. Anyone else with a specific definition? Renan, can you see the files now, PPTs? Okay, great. So this is the Company Act 2013. 13, which we will be doing after going through the Company Act of 1956. This was the this is the website. If you want, you can refer. In this, the Company Act of India is mentioned. This is the link. So in the free time, you can go through this website and explore about the Companies Act. In this site, it is mentioned that there are 4 amendments which was done in 2000, 2001, 2002, and 2006. Right, and in 2013 it is again constituted. Some major changes were done in 2013. Now let's see some of the major things which is mentioned in Companies Act of 1956. Number of individuals assembled or associated together or a group of people. Not really. Nixon, the definition which you are saying also holds for a party. In a party also people gathered. Anyways. In response to the change in business. Okay, 1 second. This part is not required. Yeah. Okay, let's quickly read this this piece of statement that found online. Under the Companies Act of 1956, the term company means a company formed and registered under the Act or an existing company, that is a company formed or registered under any of the previous company laws. The basic objective underlying the law are, now it is not that one can start any company like whenever they want. They have to first take the permission from the government of that particular company, the country, sorry. Okay, and then when the government approves it, then only one can start any company. There is a long formality of filling the forms and providing the all the documents before starting any company. Okay, Najat has joined, I think, just now. So let us. Najat, can you hear me? Sanobar, can you hear me? Both of you? Najat and Sanobar, quickly, can you hear me? Can both of you? Okay. Sanobar says yes. What about Najat? Najat is not responding. Let me type in the chat. You might not be able to hear me. Okay. So let's see. The basic objectives underlying the law are: number 1, a minimum standard of good behavior and business honesty in company promotion and management, due recognition of the legitimate interest of shareholders and creditors, and the duty of management not to prejudice or to jeopardize those interests. Provisions for greater and effective control over and voice in the management for shareholders. Number 4, a fair and true disclosure of the affairs of the company in their annual published balance sheet and profit and loss accounts. Later on, these balance sheets are audited by the chartered accountants, and then they submit their reports to the company, and then the company submit those reports to the government of that country. Proper standard of accounting and auditing. Recognition of the rights of, okay, Najar says yes. Majas, we are studying about Companies Act today in the course Business Law. Okay. Recognition of the rights of shareholders to receive reasonable information and facilities for exercising an intelligent judgment with reference to the management. So, from the shareholders' point of view, the company should be in a position to provide all the necessary information to the shareholders, right? Whatever information they want related to the profits, the losses, the assets, right? The liabilities and all things. A ceiling on the share, sorry, a ceiling on the share of profits payable to management as remuneration. The spelling is wrong here. It's remuneration. Let me write it again. Remuneration. Remuneration means the charge the company has to pay to someone for taking their services, or the salary is also referred to as the remuneration for services rendered. Rendered means services given. A check on their transactions where there was a possibility of conflict of duty and interest. And the last one, not the last one, second last. A provision for investigation into the affairs of any company managed in a manner oppressive to minority of the shareholders or prejudicial to the interest of the company as a whole. So, according to the companies, this Company Act, any company should be ready to face any kind of investigation whenever required. It is in the hands of the government. They can do any kind of investigation if they found any kind of complaints against that company. Enforcement of the performance of their duties by those engaged in the management of public companies or of private companies which are subsidiaries of public companies by providing sanctions in the case of breach and subjecting the latter also to the more restrictive provisions of law applicable to public companies. Sorry. So these are some of the key features or highlights of the Companies Act of 1956. Yeah, now let's go through the slide. I don't know why the slides are not changing. Server is, yeah. Okay, so in this we are going to go through the introduction part, then the definition, then the characteristics of the company, and then the types of a company. Sujit, are you following me? Surajit, sorry. Surajit. Surajit, can you hear me? You were typing something, you want to ask something, anything? No? Okay. What is company? A company is an artificial person created by the remuneration and see, there is only one definition, remuneration. There is no two words having different meanings. Actually, what I did now, sorry, yeah. Actually, that spelling was correct. Here it was written this This one. I wrote the wrong spelling. It's remuneration only. I just checked on Google. Remuneration is the compensation that one receives in exchange for the work or services performed. So this previous spelling was correct, not the other one. Clear? Sujit? Surajit, sorry. Okay. Fahad has joined. Fahad, can you hear me? Good evening. Welcome to IMTS. Okay, great. So first of all, a very happy Eid to you and welcome to IMTS. Today we are studying about Companies Act. Okay, great. A company is an artificial person created by law. A company means a group of persons associated together for the attainment of a common end, social or economic. According to the section 31I of the Companies Act 1956. Here, Fahad, I am discussing the Companies Act of India. Okay, defines a company as a company formed and registered under this act or an existing company. More or less, the Companies Act of all the countries are same. The basic things are same. Thus, they change some of the clauses. Existing company means a company formed and registered under any of the earlier company laws. So here they are discussing about the two types of company. One is the existing company, which was made by under some company laws before the Companies Act of 1956, and the new companies which are registered under the Companies Act of 1956. Now, characteristics of a company. A company is a separate legal entity. One second. Can any one of you tell me what do we mean by the term separate legal entity? All of you have studied in your graduation. What do we mean by the term separate legal entity? Just come. Public, private. Okay. What is anyone else? My name registered. Okay. Anyone else? Okay, most of you are more or less correct. It has some of the same rights in law as a person. Okay. Now let's take a look at the definition. Okay. A legal, I have wrote down the definition of separate legal entity in the chat box. A legal entity, typically a business that is defined as detached from another business. Detached means not connected with any other business, or individual with respect to accountability. Accountability means we should be responsible for answering any sort of questions. A separate legal entity may be set up in the case of a corporation or a limited liability company to separate the actions of the entity from those of the individuals or any other company. Clear everyone? Yes. They should accounted for responsibility. Yes, correct. Okay, Sunil has joined. Sunil, good evening. Welcome to IMTS. Can you hear me? Okay, great. So today we are discussing about Companies Act, right? I hope you can see the PPTs on the screen. Can all of you give me an example of a separate legal entity? Anyone can give me an example? Samsung, spelling is wrong, Nixon, subcontractors, Walmart, yes, very good. Okay, correct. Samsung and Walmart are correct. Next one, limited liability. Sorry. What is a limited liability company? A limited liability company is a hybrid business entity having certain characteristics of both a corporation and a partnership or sole proprietorship, depending on how many owners there are. It means that in such type of companies we can have more than one owners. Yeah. Any example you want to give? Sony. How many of you have heard the name of these companies? And user Bush, Blockbuster, and Westinghouse. They are all organized as LLC. Right. So any company which is being started in combined in partnership. Technical trading company, yes. Correct. Anyone else? the company which I presently work is a LLC company. Okay, which company you work in? Far Al Nabazo Contracting Company. Okay, Harshly. Okay, good. Okay, let's proceed. Correct. Good. Next is perpetual succession. It is what does that mean? Continuation of any firm existence unaffected by the death of its owner or the transfer of its shares to a new entity. Right. So the ownership of such companies can be transferred from one person to another. Can you name an example? Anyone? Perpetual succession. So it comes from group of markets. Okay. Care for. Okay. 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 Correct. Next one is common seal. What do we mean by that? Common seal? It is also referred to as the company seal. Common seal or company seal. Both are same things. It is an official seal used by the company, or we can say the logo. It is used by the companies in common law jurisdictions. Logo, yes. It is also referred to as company seal. Here everyone, any doubts? Or we can say the company uses it as their signature. Next is transferability of shares, transferring of shares from one individual to another. And last one is separate property. Here, separate property means having your own individual property. What does separate property means? I just told you the property owned by an individual. Is We'll go through it in detail shortly. See this separate legal entity. This was the first point, I think. So let's quickly, yeah. Now let's see some of the features. I already told you separate legal entity. A company is in law regarded as an entity separate from its members. It has an independent corporate existence. Any of its members can enter into contract with it in the same manner as any other individual can, and he cannot be held liable for the acts of the company, even if he holds virtually the entire share capital. The company's money and property belongs to it and not to the shareholders, although the shareholders owns the company, right? So the individual will be responsible for all the proceedings in such companies. Next we discussed was limited liability. A company may be a company limited by shares or a company limited by a guarantee. In a company limited by shares, the liability of members is limited to the unpaid value of those shares. Next was perpetual succession, which I already discussed. Being an artificial person, a company never dies. I told you that the ownership will be transferred from one person to another. Nor does its life depend on the life of its members. Members may come and go, but the company can go on forever. It continues to exist even if all its members are dead. The existence of company can be terminated only by law, right? It means that a company's existence persists irrespective of the change in the composition of its membership. Next, I discussed was the common seal or the company seal. It is the signature used by the company. Since the company has no physical existence, it must act through its agent, and all such contracts entered into by its agents must be under a seal of the company. The agent has the seal of the company, right, as a proof that they are a part of that company. The company seal acts as the official signature of the company. Now the authorized person cannot go to various cities to sign the documents, right? So what they do is they release the seals to all the agents, where the agents can put the seal on the document and it will be considered as the authorized signature. Next is transfer. Someone has joined. Let's see who has joined. Suvit Lal. Suvit Lal, can you hear me? Good evening. Welcome to IMTS. If you can hear me, you can respond to me in the chat box. Okay, great. So I think you are having this as the first class with me. So my name is Vashisth. I am from India. I've done my MBA from IIM Lucknow. Okay, great. So I hope you will enjoy this class. So today we are discussing about Companies Act. Okay. Whatever part you have missed, you can go through the recorded lectures, recorded classes after the class. Transferability of shares. The capital of a company is divided into parts called shares. Capital means the money invested or the profit. These shares are subject to certain conditions, freely transferable, so that no shareholder is permanently wedded to the company. When the joint list of companies were established, the great object was that the shares should be capable of being easily transferred, or we can say the stake in the company. Separate property. Fahad, you are asking about separate property. As a company is a legal person distinct from its members, it is capable of owning, enjoying, and disposing of property in its own name. Although its capital and assets are contributed by its shareholders, they are not the private and joint owners of its property. The company is the real person in which all its property is vested and by which it is controlled, managed, and disposed of. So here they are trying to say that the company can buy any other property in the form of buildings or any other assets, and the owner of that property will be in the name of the company only, the original company, right? And so the companies, what they do, they buy any lands or any companies, and then after a certain time they sell those property. Yes, fixed assets. So they buy and then they sell and then they make profit in that. So all the proceedings should be done in the name of that company only, not in the name of any individual or in the name of any shareholder. Clear part? Okay. Everyone clear? Sumit clear? Sunil, Prabha, Renan, Najat, Nixon, Rezi, Suvijit, Monachin. Okay, great. Now let's go to types of companies which are registered under the Companies Act of 1956. So which we are discussing specifically about the Companies Act of India, right? As I have studied Companies Act of India during my studies. Okay. So under the companies we have 1, 2, 3, 4, 5 types of companies. One is incorporated, second one is liability, third one is number of members, fourth is control, and fifth is, okay, you are from Dubai, okay, fine. And last, okay. So with more or less in the various countries, the Companies Act is same. The basics of the Companies Act is same, right? So it won't make any difference. Okay. Okay, Tijo has joined. Tijo, good evening. Can you hear me? Quickly, you can respond in the chat box. Welcome to IMTS. Okay, great. So today we are discussing about the Companies Act. I hope you can see the files on the screen, and whatever part you have missed, you can go through the recorded classes. Yes, you have joined late. The class started on time. What do we mean by the term incorporated? A company or any other organization formed into a legal corporation. United into one body. So in incorporated we have 3 types of companies. One is the chartered companies, second is statutory companies, and the last one is registered companies. Can anyone of you tell me what do we mean by chartered companies? Anyone? Is an association formed by investor or shareholders for the purpose of it. Audit firms. You are saying with respect to the term chartered, correlating it with chartered accountants, but that's not the case here. See, chartered companies are were usually formed, incorporated, and incorporated means making everything into one single body, and legitimized under a royal or in republics an equivalent government charter. This document set out the terms under which the company could trade, defined its boundaries of influence, and described its rights and responsibilities. Clear, everyone? How many of you have heard the name of East India Company? How many of you have heard the name of East India Company? All of you have studied in history during your school days. Okay, now read this line. The best known examples of chartered companies are the Dutch East India Company and the British East India Company. But there are many other examples from the 17th and 18th centuries. Chartered companies were formed when individuals sought government sponsorship and protection for their efforts to colonize new areas or open new trade routes. I'm not sure, Najil. I think they are closed. Or maybe they are running with a different name. I'm not sure. You have to check on Google. Colonize new areas or open new trade routes. MA Yusuf Ali is buying shares now. Okay, someone has joined. Ramesh. Ramesh, good evening. Can you hear me? You can respond in the chat box quickly. Ramesh, can you hear me? If you can hear me, you can reply in the chat box. Anyways, next is the statutory companies. What are statutory companies? Anyone? When a company is incorporated or formed by passing a special act at the legislature, it is called a statutory company. For example, Reserve Bank of India, LIC, Food Corporation of India, These are the examples. Now, such companies are formed mainly with an intention not for the private business, but to serve the people, but to serve the common man, to fulfill their needs like gas, water, electricity, banking, right? Like food, take the example of Food Corporation of India. What does it does? It does not do any business for itself. Social service, yeah, we can say that. Not social service, but service for the common man. Okay. Food Corporation of India, LIC, right? And only government organizations comes under statutory companies. Service for citizens, yes. BSNL, yes, very good. There are so many. ONGC, BHEL, so many. Shiful, good evening, boss. How are you? Happy to you. Naj, Rami is very happy to you as well. Sorry, I forgot to wish you. Today we are discussing about Companies Act. Okay. And next is the registered companies, which we have already discussed. The companies which are registered under the Companies Act of 1956. Next comes the liability. The Shara is over anyways, thank you. Limited liability. What do we mean by the term limited liability? Anyone? See, limited liability is the, we can say, limited exposure to financial risk by investors of a company or a partnership. Now read this. One second. Risk will be limited, yeah. Okay, read this. How it works. In certain cases where an investor invests his money with a company or partnership, this investor will not be liable for any financial risk beyond what he has invested in the business entity. These type of entities are normally limited liability partnership arrangements and limited liabilities companies. For example, if an investor enters into an agreement to join a LLC company, his investment of $100,000 in his total liability. In other words, he can potentially lose of this and no more. It means that if he has invested $100,000, he can only, if the company goes bankrupt, then he can only, he will be only responsible for those $100,000 as a loss, not more than that. He has nothing to do with other, how much other partners have invested. He won't be liable for any other liability beyond this initial 100,000. If he were to invest additional sums, this limited liability would then match his total contribution. Sole proprietorships and general partners in general partnerships, on the other hand, have unlimited liability. Clear, everyone? Okay. Sorry. Okay, next. Unlimited liability also, where there is no liability. Right, so clear? We still have 5 minutes left. Okay. This is good to go. So, any questions up to now? What I have explained? Is everything clear to everyone? Prabha says no. Prabha, do you have any doubt? Okay, okay, okay. Chartered company. Mm, one second. Bank of England is also an example. Bank of England. So I think we should stop here and we will continue with the same topic tomorrow. There are some parts left which I will be covering tomorrow and then starting the new topic. Okay, since I think all of you have already taken free class, so I don't want to teach more. I will teach more tomorrow. So thank you very much all of you. Good night. See you tomorrow. Thank you for attending the class.